Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hey, I'm Doreen So.
And I'm Mark Lahn.
Welcome to Hull on Estates. You're listening to episode number 712, and today we'll be discussing a case called Hotner and Norman. It is about what happens when one family members is alleged to have really done some financial abuse to an elderly person after their death. Mark, how are you?
Pretty good yourself.
I'm good. I'm good. You're sitting in front of like such a stately background. What a
I'm
beautiful
sitting in
library you're in.
I'm sitting in the Hull and Hull library here. We have a lot of resources. It does look like a fake background, but I assure our viewers it is not.
Yeah, and I assure our viewers that this is blurred for a reason. What's behind me is also very real. As a litigation lawyer, it's just boxes of evidence in my various files. Mark, do you want to sort of like start us off with a bit of the facts in this case? It's actually like quite a juicy read, and I always encourage everybody to read like the case whenever you hear a case being talked about, even if like you see like Mark's amazing summary in our books, it's always worth reading it because like that's where you really get to put yourself into the shoes and in the minds of like judges. So if you want to know like how judges think, what they'll do. You want to think about how you want to advocate when it's sort of like your first time up at a hearing or it's your 30th time up at a hearing. It's reading these reasons that really sort of like helps you understand like the thought process. And I think a case like this, like there's no better demonstration if like once you hear the judge describes what happens, there will be no question or doubt as to what the outcome is. There are no surprises here in terms of like the outcome. I'll just give that spoiler alert right up at the top because you're going to be able to guess it right away. But Mark, take it away.
Sounds good. And like you said, Doreen, like I did a brief blog on this one. And I really couldn't get into all the facts because there's so many little details to this case. And like you said, it's fascinating, but it is an unfortunate tale of some pretty clear financial abuse against an elderly person. So I'll just jump right into it. So the case centers around an individual named Annie. So Annie, at the time of her death in 2021, was 96, and she was predeceased by her husband, John, who died in 2016 at the age of 94. So we have an elderly couple here, and the story really begins to start as soon as Annie's husband, John, passes away in 2016. So we have, a daughter that kind of swoops in here as soon as John passes away and starts to have increased involvement in Annie's finances. So it starts with being added as a joint account holder on Annie's accounts, as it often does. I not sure if it was mentioned in the case. I suspect it was to assist with paying bills and whatnot, which is really quite common. But in this case, obviously, we have a family. There is 6 children. I think one of the key points really is that Annie's will doesn't benefit the daughter who's added onto the joint account. Whose name is Elaine. So Elaine is kind of the central character here. And I don't think, Doreen, like in the facts of the case, it really got into, why Elaine may have been excluded under the will. We really don't know. But all we know is, she's added on these joint accounts, but she's not a beneficiary. So it's the estate trustee that comes in as soon as Elaine dies and wants to know what happened here, because what happened between 2016 and 2021 is almost over $1 million in Annie's funds that were spent or gifted by Elaine. So it kind of starts with Elaine's going to move in. She's going to provide caregiving services for Annie. It starts at more reasonable amounts, and I think at its peak was $8,000 a month for what she described as 24/7 care all the time. So that's kind of the progression as far as the monthly draw that was being taken from Annie's accounts. And then in addition to that, we also have some very significant gifting to family members. We have a full renovation of Annie's house from top to bottom. The judge remarked that the listing photos were beautiful by the time the house was sold. So we have the use of Annie's funds on a significant renovation. And basically, as the judge was reviewing everything, they found that there really wasn't detailed accounting for any of this or explanations for any of this. And this was
Yeah.
all in the face of starting in 2015, Annie, started to exhibit signs of cognitive decline. And by 2016, there's a MoCA test of 5 out of 30. So obviously, very profound cognitive decline right as these transactions start to ramp up. So that's
Yeah.
kind of the backdrop as far as some of the facts. There's probably some other facts, Doreen, that you found
Oh
that
my
jumped off
God.
the page because there's just
Yeah,
so much here.
just dying to get at some of these very specific facts that the trial judge really just paragraph by paragraph. It's like boom, boom, boom. It's shocking. But, you know, Annie dies with basically like nothing left,
Yeah.
right? And if you put yourself in that estate trustee's position, that's one of the other children, one of Elaine's, her brother. And like you think back to like what must be in his mind, which is like our parents had a house. I understand like the house was sold like pretty soon after John, their father, died. I think it was in the year of his death, and that's when Annie moved into Elaine's house. So at that point, everything was cashed out. So then where is all the money? Like, they must have thought like the house would have sold for something. Like, and there probably wasn't like a huge mortgage left. Um, how could it have gone to zero in 5 years? This was like a modest family. It's your average Canadian family. And, Fred was probably thinking, like, I didn't really see mom needing like 24-hour care. She wasn't living in like a retirement home that like costs like $10,000 a month and like all that kinds of stuff. So really, like, where did all the money go? Interestingly enough, by the time like Fred brings like an application, Elaine, through her first lawyer, consents to pass her accounts as an attorney for property. And so that's what you see the judge going through when we say like there's these juicy facts is it's a very much like a line by line review of Elaine's voluntary court format accounts for these 5 years from 2016 to 2021, along with like all the additional affidavits that like Elaine had also put forward, as well as from like other family members to try to like then justify how it could have actually like gone down to zero. Now, of course, like taking care of like any individual, especially an elderly individual, if they have like high like medical needs, care needs, all of that could be like very expensive. So that would have been fine if that's what her account showed, if they were like proper expenditures for the care of Annie. That's not really what happened. Like, I don't know, Mark, do you want to start us off with like maybe like one of your favorite comments from the decision or something? I just do a
I
few.
mean, there was just there's so much here. Like I mean, the house renovation I think is big, but then there was also 189,000 of for gifts and future bills. But yeah, 508,000 on home renovations, 411,000 in caregiver fees. So
Yep.
I mean, you kind of think like exactly as you described. the all the kids, they're probably not keeping close tabs on what Elaine is doing, but I'm sure they all have in the back of their mind thinking, our parents had a house, we'll get a little sum on their death, and then everything's gone. And you even kind of contrast like 411,000 in caregiving fees. I mean, if even if Annie had been put into, a subsidized, 24/7 long-term care, it may not have even have reached that amount over those years. But yeah, it's just shocking. And the judge,
It's
yeah.
wild. Yeah. I mean, like, and you said it. You said future bills was one of the disbursement entries. Like that is a clear no-no when it comes to fiduciary accounting. This is not like a holdback for like rainy day expenses. At that point, that money should still be in the account. This is money that has like left Annie's account, went into Elaine's, and the explanation was future bills. Like, what does that mean? What is that for? Um, there's $400,000 one day as a gift from Annie to Elaine, and that is a big amount of money. That is a huge gift. And that's obviously a huge gift that actually undermines like the will, right? And what the estate plan is supposed to be. That at that point, what would be left for the beneficiaries under the will? And in this file, there were like also medical records produced. And when the judge was sort of like able to sort of like take the chronology that was put forward in the medical records, compare it to like what she sees chronologically in the accounts and some of the like the timing of this gifting, it was horrific, right?
Yeah, and when
Um,
we like kind of go into the analysis a bit, like Elaine was able to produce, and she did produce a number of affidavits from family members who apparently corroborated some of these gifts. It was gifts to themselves, but the judge effectively found that when you think about Section 13 of the Evidence Act and the corroboration that you need, I guess none of the affidavits really touched on the fact that Annie had some profound cognitive decline, and that wasn't addressed in the affidavits. And
mhm.
so the judge didn't find that the affidavits were compelling in saying that Annie had, knowledge and approval of these gifts that she was allegedly making.
And in a way, like when I read that section of the judge's like thoughts on all these like supporting affidavits from like other family members and neighbors saying that like, we think like Elaine is a good person. She took care of her mom, like nothing bad happened. And then the way that just sort of like broke it down and was like, I bet these witnesses didn't know about like the extent to which like the medical records show that like Annie was in cognitive decline. I bet they didn't know about the size of these gifts. I bet they didn't know this. I bet they didn't know that. And I was like, wow, this is how I'm gonna do my next cross-examination.
That's exactly it. I mean, because that's exactly it. They didn't know the extent of the cognitive decline. And I think that was a major problem as far as corroborating these gifts. I think an interesting comment in this case, and it kind of ties into the conclusion too, is that, the judge did find there was some value to the caregiving that Elaine provided, maybe not at the level that she claims, but there was a value to it. There was no criticism that I saw in the decision as far as the care that was being provided. I don't know if it was mentioned in the decision, but my guess is this was a family where everyone was kind of happy that Elaine was the one taking on this role and being there with their mother over these years. They obviously didn't know the financial impropriety that was going on, but it seems like there wasn't any allegations of abuse that I saw. So I mean that's an interesting distinction here, where like they are going to come back and try to quantify the caregiving that was provided, but it obviously won't be at the level that Elaine was claiming, and then she will have to repay some of these, all the gifts that she took and whatnot, which is interesting because some of it was gifted to other people, so she'll effectively
Yeah,
have to make the
yeah,
estate whole.
right. Yeah, and that's exactly sort of like that top line outcome, which is everything has to be paid back to the estate. What makes this legally interesting is also like, so then on what basis is this judge ordering Elaine to pay everything back? This is the one where like what you hear the facts, you know what the outcome should be. So like it's like you know what the remedy should be. Everything should be paid back. But then on what basis can you craft that cause of action that would lead to like that type of remedy being like available and appropriate? And here the child judge did have to like take a minute and think about it because even though Elaine did volunteer to like pass her accounts as an attorney for property. Elaine was actually never an appointed attorney for property. That joint account that you speak of, actually, like the monies didn't come out of that account when the house was sold. Elaine actually just put the entire sale proceeds into like a bank account of her own. And so at that point, where is like the obligation like not to steal from your mother, right? Like, is that like such a like in a way like a silly question? The obligation is obviously there. So here the judge resorted to like good old like fiduciary relationships.
Yeah.
You're clearly holding this money in trust for your mother. You had an agreement with your dad before he died that you were going to take care of like both parents. Your mother's living with you. You're holding on to her money. It's obviously for her benefit and not for your own benefit. And also, even before your mom died and as well as after, you were also representing yourself as like the person in charge of your mother, person in charge of her finances. You even told like the funeral home that you were the POA even when you weren't. So at that point, yeah, court did find that a fiduciary relationship existed. It found a breach, and the remedy was just paid all back. Just paid. Mark, do you want to then talk about that three-part test and like when a fiduciary relationship arises in the eyes of the court?
Yeah, so the court applied the three-part test in Frayne and Smith. So the three parts are a discretionary power over finances, the unilateral ability to affect interests, and the vulnerability of a beneficiary. So obviously the third part is easily satisfied here with significant cognitive decline in her dependent state. Yeah, the court very, very easily found that Elaine had complete control over the accounts and was making these decisions unilaterally. So the analysis under Frayne and Smith was very straightforward in this case as far as finding a fiduciary relationship. And obviously, in those cases, you can only be making decisions in the best interests of the person who you're holding funds for. And I think the court and maybe the parties considered some other arguments too, like resulting trust and different other remedies that can be applied in this case. But ultimately, it came down to, like you said, the good old fiduciary relationship. And yeah, this case is a little different because oftentimes we're arguing over an attorney for property. It's very clear what their obligations are under the Substitute Decisions Act. In this case, we come back to kind of common law principles. And so we can see here if anyone's ever dealing with a situation where an adult child is misappropriating funds and they're not in a formal relationship like an attorney for property, then this is a good case you can kind of rely on.
Right, right. Yeah, right decision, especially in light of the facts the way described by the judge. One last thing I think I would want to sort of like just mention because, sometimes like these scenarios, like it's almost always like the same story, but the elements of the story could always just be like slightly different. Did you actually have POA? Or maybe you had POA, but you say you never used it. You were always acting on the instructions of the parent. Or maybe you were actually just added on as a joint account, and that's how you had that like authority and like the ability to actually like get into the funds. Like all these different things, it's just variations on the same theme, but like legally it could be like a little bit different. Even in those instances where the person is arguing that, okay, I was named as a POA, but I never used it because dad was capable and dad told me to do XYZ and I was just doing what dad was telling me to do. At that point, you are still a fiduciary for dad because you are at that point dad's agent.
Yeah.
When you are out there in the world carrying out dad's instructions, that those same three elements that Mark that you just listed out is still there for an agent and principal relationship. There's also maybe just like a less well-known part of the Courts of Justice Act where there's a provision in there that allows a joint account holder to compel the other joint account holder to account for the funds in their joint account to them. And that is different than the accounting under the SDA that you often requires like leave of the court before you can get an attorney for property to pass your accounts to an estate trustee.
Yeah.
So something to think about. Like there's lots of like different ways you can like craft a pleading to really get you to where you need to go at the end of the day. But you know, something I said to you, Mark, like earlier at lunch when we were just like talking informally, it's like it's actually remarkable the extent to which like Elaine was just so brazen with her description in her accounts. Like the reason why the judge was able to pick at all these transactions is like because the way she described it all. $400,000 on a day where, cognitive decline is already like rather severe. Well, that like, hello, red flag. And like when
Yeah.
your compensation as a caregiver keeps like going up and when you're charging like $50 car rides
Yeah.
to take your mother anywhere, even my Ubers cost.
No, that's exactly it. And yeah, I mean, one of the comments in the decision was just they kind of said after the fact, oh, I mean, she technically didn't have leave of the court to force us to pass our accounts. And the judge kind of said, well, you agreed to it, and that's what you did. So, I mean, if you're gonna make that objection, you'd certainly have to make that, earlier in the process, not produce your account and then say, oh, maybe the court shouldn't rely on it because there wasn't leave. At that point, all this information was out there. So,
Yeah.
I mean,
Yeah.
for me, like just some of the key takeaways, like especially for family members, like it's and we see this a lot, like you really can't bury your head in the sand as far as just hoping that mom's finances are being managed okay. Like I do think people should try their best to make sure that the people either appointed informally as an attorney for property or not are being transparent about what they're doing, and get the family involved. And that's one here where it wasn't clear to me what exactly the family dynamics were that may have, lended themselves to some of the estate planning. But those are the kind of things that can sort of avoid these situations at the outset. Certainly having, a formally appointed attorney for property is helpful as well.
Right. Okay, there you have it. That concludes our podcast. Until next time, we want to thank you for listening. I'm Doreen So.
And I'm Mark Lahn.
Should you have any questions, please email us at info@hollandhull.com or contact us through the contact page on our website. Thanks, Mark.
Thanks.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hollandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.